And welcome everyone to our webinar discussing the Russian sanctions and particularly the effect that they are having on investment advisors. And we have with us here our guest speaker from Dechert, Darshak Dholakia. So welcome, Darshak. I know you've been spending a lot of time on these issues. And so as Lisa mentioned, we will be taking questions. We've set aside 15 minutes at the end to address your questions. So please do type them into the chat box. And you can type them at any point. I'll be taking a look at those questions and presenting them to Darshak at the end. So with that said, let's get started. So Darshak, I know these sanctions that are being imposed on Russia have been sort of evolving at a rather quick pace. In fact, they started even before the invasion of Ukraine took place, and they certainly ramped up since then. And I think in the early days, it seemed like they were being imposed every day. And to me, it seems like things have perhaps settled down recently, but then I'm hearing that in light of some of the images that have come out in Ukraine over the weekend, that the U.S. is considering further sanctions. So, I was hoping that you could discuss today, and I know you have your slide presentation, and we sent that out prior to our meeting today. But I was hoping what you could talk about is sort of the current state of affairs and any recent developments that have happened, and then we can maybe go from there. So at this point, I'll turn it over to you.
Great. Yeah, thanks, Sanjay. I'll put the slides on the screen in a second, but I think that's a great place to start from is, at this point, the sanctions aren't new. I imagine that everyone who's on this call has had to, answer some question or study them in some form, given that they've been out for almost a month and a half now. So apologies if the first part of the presentation is a bit academic, because I just want to make sure we're all kind of like on the same level field, so we all understand exactly what the current sanctions are, and then we can talk a little bit more at length at the end about what could happen. But I think you're generally correct that the first, February 21st is when the first round of new sanctions started coming in, and that was pre-invasion, but essentially once the regions of Ukraine, the Donetsk and Luhansk People's Republic, they declared their independence and Russia recognized them, which was a pretty significant escalation in terms of the foreign policy mechanisms in play. So again, they didn't invade Russia, they hadn't invaded Ukraine yet. But once Russia recognized those regions as independent, the US and EU and UK started imposing sanctions. Once Russia invaded Ukraine, the sanctions came much more frequently. There has been a bit of I don't want to say a full pause, because there's many measures being discussed, as you said, in light of a lot of the civilian casualties that appear to have happened in Kyiv. But I think the challenging part in the beginning was that these sanctions are in many ways novel. It's not just sort of like a rinse and repeat of other measures that they've used in the past. Many of the measures are very sort of like targeted in an attempt to sort of like minimize the damage on US investors and US people in general, as well as EU, while inflicting maximum pain on Russia. So in the past, when I started practicing sanctions laws, usually it was you can't do anything with this person, or you can do whatever you want with the person. It's kind of very black or white. And we're way past that, like starting with Iran, but really under Russia, there's been a lot more nuance involved, where you might be able to do specific types of transactions with a certain entity, but you can't do other types. And it all depends on whether these are meant to be like restricting their access to capital markets, restricting their access to US goods, restricting their access by US investment. There are many, many buckets now. And at least at this point, I think we have all the buckets lined up. It's just a matter of like which companies go into each bucket. So the challenging part was, I'm stretching this analogy far too far, but like figuring out what bucket meant what was really difficult because they were all new. But now at this point, we have the framework and the rubric, I think, pretty well set in place. And then it's just a matter of making sure you're looking at the most updated lists so that you know exactly which companies continue to be subject to what restrictions and making sure those don't change. Does that make sense?
Yeah, and I think it's good to sort of step back and sort of see where we are. I know folks have probably been able to watch a lot of webinars. In fact, I know Dechert and yourself have put out some webinars on this topic. But I think it does make sense to sort of sit back, get the lay of the land, and sort of reassess and then move on. So yeah, no, this is great. So let's get started.
Great. Hopefully everyone can see my screen. Just let me know if there's a problem.
Yeah, no, I think we're good.
Okay. So I want to focus on a few discrete topics, and then at the end I have kind of like a catch-all about like additional issues to consider. So I wanted to start out talking about the sanctioned banks because that's been the most significant impact for the investment community. Talk about the current restrictions on Russian sovereign bonds, new debt and equity restrictions that have come out, which again are specific to the investment industry, but are in many ways are more narrow than they appear to be on their face. Then I want to discuss the effect of sanctions on Russian oligarchs and the ramifications on the investment industry, sort of general grab bag of summary of other export and sanctions restrictions, because even if they don't directly affect your investment activities, you may be asked about them, or they could have an impact on target companies that you invest in. So again, just to make sure we've covered the whole waterfront of all the measures that the US in particular, but also the UK and EU are using or employing against Russia. And then finally, I just wanted to raise, again, some specific issues that have come up for investment advisors, both with respect to investments that you make, but also with respect to investors whose money you may manage. And as Sanjay said, feel free to send questions throughout. We'll probably wait until the end just to cover them all, because in some ways the last few slides are a bit repetitive, but just wanted to make sure that you can understand all the full ramifications of the measures that I'll talk about in the first few slides, and then we can talk more about like practical considerations near the end. In addition, the whole thing is intended to be practical, but there might be some nuance that I missed when I'm just describing the restrictions themselves. So, and I'm going to try not to sort of like get into history much, like what happened when or how they differ from older restrictions. I'll really just try to focus on what you need to know right now. But in some cases, history is useful just so you can understand what changed and why. So the first major round of sanctions, again, the first sanctions happened on February 21st, which is when VEB was added to the SDN list. So VEB is Vneshny Bank. It's a large government-owned bank in Russia. It was added to what's called the list of specially designated nationals, the SDN list, and that's like the really bad list. That's where the terrorist groups go, the human rights abusers, the government of Iran. It tends to be the most restrictive set of sanctions, where in general, once you're on the SDN list, US persons can't do any business with you or with any entities that you own or control, or deal in any property or interest in property of an SDN, unless there's a general license. And I'm using a lot of terms, and all those terms have definitions, but property or interests in property is defined very, very broadly to include any instrument or contract in which an SDN has any interest, past, like at present or contingent. And OFAC has interpreted this broadly to include secondary market securities issued by SDNs are generally considered to be off limits for US person investment unless there's a general license that applies. And so here, again, VEB was the first one to be added. But then on February 24th, a number of other banks were sanctioned as well. VTB, Bank Odkrity, Sovcom Bank, Novacom Bank, and Promsvyaz Bank, again, all the ones on the second sub-bullet other than Sberbank, they were all subject to SDN restrictions, again, the most restrictive list. But Sberbank was not added to the SDN list, and it remains not subject to an SDN listing. What that means, and I'll talk about Sberbank in a second once I talk about the others, because the others are actually more easy to understand what the restrictions are. Again, as a general matter, once these banks are added, VTB, VEB, Odkrity, and Sovcom Bank all had publicly traded securities, a combination of debt and equity that are widely held by U.S. investment advisors. I'm sure many of you hold them as well. And what that means is, unless OFAC were to issue a general license, which they did, then U.S. persons typically would have had to freeze and could not trade, can't buy anymore, can't sell what securities you had, any of those securities of an SDN. But OFAC issued a general license called General License 9, and now it's 9A because it was updated somewhat. And what this means is that U.S. persons, U.S. funds, U.S. investors are permitted to continue to hold any of those securities issued by the SDNs that you currently held when the sanctions came out. You can sell those securities to non-U.S. persons, presuming you can find a buyer. The only thing that's prohibited right now is for you to purchase or increase your holdings of those SDN securities. So again, it's important to note that in other instances, if a company were added to the SDN list, the intent is to freeze their assets. Like the U.S. doesn't want their assets going back to them, or they don't want them to have access to funds that are under U.S. possession or control. But here, there's a broad carve-out, which is similar to what's been done in the Venezuela bond context, and was also the case in 2018 when Rusal and EN Plus Group and a few other publicly traded Russian companies were sanctioned. This is kind of like the new normal from OFAC when it comes to targeting trades in publicly traded securities. For those of you who are familiar with the China sanctions, the CMIC sanctions, it's the same standard where you have a period by which you can divest if you want to. You are not required to divest these Russian securities. So if you hold them up to May 25th or after May 25th, then at that point, this authority for you to have to sell to non-US persons will disappear. It'll expire on May 25th. So again, unless that license is extended, any SDN securities that you hold past May 25th, you will then have to treat as block property. And that means that you'll have to freeze them. You won't be allowed to sell them. You'll have to in general, you're supposed to put them into a segregated account. That's more for bank accounts and things that they're easily movable. It's a little bit trickier when it comes to securities that may be held by a fund, but effectively you just have to make sure that it has adequate protection around those securities so that they're not sold unless and until OFAC gives you authorization to do so. And this General License 9A covers all these banks: VEB, VTB, Sberbank, Odkriti, and Sovcombank. What it doesn't cover, it's not every single bank. So there are other SDNs that are outside the scope of this general license. It appears that those banks were purposely left out because they don't have publicly traded securities. They're like the military banks of Russia, so they're purely meant to finance business of the Russian military and the Russian government. They don't have the same exposure that VEB, VTB, and others did. So they were very knowingly excluded from the scope of this. But any of the banks that have publicly traded securities and have been sanctioned recently should be covered by these. And it applies not only to the banks themselves, but also to any subsidiaries of the banks, which is an important distinction for SDN sanctions, is they apply in full to any entity that is 50% or more owned by a listed SDN. So what this means is, VTB is the bank that's sanctioned, but VTB Capital, PLC, for example, is also caught up by the sanctions because it is a wholly owned subsidiary of VTB Bank. This General License 9A is specific to trades involving bonds or securities issued by the banks, the SDN banks. There were other general licenses in place that permitted the orderly wind down of other activities with SDN banks other than holding securities. So what this meant is if you were procuring research from VTB, then once they're added to the SDN list, you're not supposed to buy that research anymore because you're now dealing with an SDN. Again, these general licenses they gave about a month from when the banks were sanctioned to wind down all the other activities. So they've now expired. So at this point, US persons aren't allowed to have any business dealings involving VTB unless it relates to debt or equity issued by VTB and that is covered by General License 9A. Otherwise, you should not have any relationship with VTB or its subsidiaries or these other SDNs, where they're acting as a custodian or sub-custodian for a fund of yours, where they're acting as a broker-dealer, where they may be providing marketing support, where they might be providing research to you. All of that is now prohibited. There was a period of time up until the end of last month where you could have continued that, but at this point you can't. This is a good opportunity to talk about Sberbank, because Sberbank, unlike these other banks, Sberbank has not been added to the SDN list. It's subject to a special type of sanction where US banks, US financial institutions, are prohibited from engaging in transactions involving Sberbank or property or interest in property of Sberbank unless it's covered by a general license. And those restrictions, they were a bit odd because they took effect late. So the restrictions came out, the rules came out in February 24th. They didn't take effect until March 26th. So what that means is that as of March 26th, US banks, again, only US banks, not US persons more broadly, but US financial institutions. US financial institutions are now prohibited from dealing with Sberbank or transactions involving Sberbank property, which OFAC has specifically defined to include depository receipts and other securities issued by Sberbank. So a U.S. custodian or a U.S. broker-dealer or a U.S. bank won't process a transaction involving Sberbank or Sberbank securities unless it's pursuant to General License 9A. So it's created this weird kind of a group where U.S. persons are not prohibited from holding Sberbank stock because it's not an SDN. So we don't need to rely on the authorization of General License 9A to continue to hold, to continue to accept dividend payments or to sell the securities to other people, because the securities themselves aren't property of a blocked person because Sberbank isn't blocked. But if you're using a U.S. bank or U.S. financial institution, they will no longer process your purchase of a Sberbank security because that's not covered by General License 9A, and U.S. banks are prohibited from dealing in Sberbank property. So Sberbank is effectively, from a bank perspective, being treated as an SDN. Again, I don't want to spend too much time belaboring the difference. It's important with respect to like the ramifications for what happens if I hold Sberbank stock after May 25th. You know, if it were a VTB security, then that would have to be blocked and segregated and reported to OFAC. Sberbank securities actually do not, because it's not blocked property. There's nothing to block because Sberbank is not sanctioned right now in that manner. But what that means is they're functionally illiquid if you have a U.S. custodian or U.S. broker-dealer, which are captured in the U.S. financial institution definition, because they're not allowed to do anything with the security. So you are effectively handcuffed with it at that point. So again, just to briefly summarize, U.S. sanctions, once an entity is put on the SDN list, all securities that were, even those that are already on the secondary market and already being traded and already out of the hands of that sanctioned entity, those are all considered blocked unless there's a general license. There is a general license permitting trades, but trades to non-U.S. persons are continued holding, but that authorization is going to expire on May 25th. An important distinction is under EU-UK sanctions. Again, I'm focusing mostly on US for this presentation, but I'll try to note differences from EU-UK where applicable. So the US sanctions, investment advisors can't trade in these securities unless it's authorized. EU-UK sanctions, even if they impose a full asset freeze on the company, previously issued securities that are already on the secondary market are actually not technically captured as prohibited property of a UK or EU asset frozen company. So it's a weird divergence where if you're a US advisor and there's a UK or EU sanctioned company, but that company is not sanctioned in the US as an SDN, then you can actually continue to freely trade in secondary market trading of those securities. Any new securities that are issued by an EU or UK asset frozen company would be restricted under EU-UK sanctions because those are considered to be funds or economic resources of the asset frozen company. In addition, you could also be restricted from receiving any dividends or coupon payments or principal payments related to any securities of those asset frozen companies, because it would be the company that would be sending its assets to fulfill those obligations. And EU-UK banks, EU-UK persons have to freeze any assets that they get of a frozen company. So there's still some knockdown effects from holding a security, even if you're allowed to hold the security from an EU-UK perspective, but you're not subject to the same restrictions as you would be under US sanctions with respect to needing to rely on a general license to continue to hold or to sell and being prohibited from purchasing. None of that is a concern for EU-UK sanctions. And that's important because, as I'll talk about a little bit later, in many ways, honestly, one of the more challenging parts about this set of sanctions, the new set of sanctions against Russia over the last month and a half, have been how it's not only the US who's the leader now. Traditionally, the US has taken the lead and other jurisdictions have followed pretty closely. But now we have the EU and UK, which are often taking their own lead in certain areas. And in some ways, the concepts still are similar, but they all want to challenge Russia banks or Russian energy companies, but the specific lists are different. And then the ramifications of being on a list are different depending on whether you're on a US versus an EU or UK one. So there's cooperation when it comes to the types of sanctions that are being imposed, but there's increasing divergence in the specific targets that are imposed under each regime. So many of my clients still try to take a sort of like one-size-fits-all approach where they apply the sanctions globally, US, EU, and UK at a minimum, just because they want to avoid a foul up if someone in the UK is routing a trade through Luxembourg or on behalf of a Luxembourg fund. It has to be approved by a US-based PM. But they don't want any one of those jurisdictional elements to then cause a problem for the entire trade in general. But it is getting challenging, and I'm sure I don't have to tell you guys on the phone, but it is a growing challenge to sort of keep abreast of all the different ones. And in some cases, it does require a bit more of a nuanced approach rather than a one-size-fits-all, because what you might be able to do under one regime, you might be prohibited from under another. But if you are entirely confident that that other more restrictive regime doesn't apply to the specific activity you want to do, then maybe you can grant an exception to your general policy of saying, well, we comply with all sanctions globally as if we are subject to all of them. Just an issue for consideration, and to the extent there's specific facts or fact patterns you guys are wrestling with, we can try to deal with that under the other question section. And the only other point I'd flag is that Canada has taken a more restrictive approach than any of the US, EU, UK in many regards. They've added far more companies to their asset freeze lists. So the impact of that, if you have Canadian operations, can be pretty significant because, for example, Gazprom is subject to some limited restrictions, which we'll get to in a minute, where US and EU and UK persons are only prohibited from dealing in new securities issued by Gazprom after February 2022. But in Canada, there's a full asset freeze that's in place. So if you have a Canadian fund or Canadian investor that holds Gazprom securities, that's a much bigger problem than if you had a US person who holds previously secured Gazprom securities, because those aren't restricted under the US. So again, that's just an example of where this growing divergence among the regimes can cause some problems. But I'm going to try to focus on US here. Russia sovereign bonds, another hot topic. So all of the US, EU, and UK sanctions prohibit dealings in any new Russian sovereign bonds that have been issued after March 1st. As a general matter, the US was the only regime that previously had any sanctions targeting Russian sovereign bonds before late February. But those were very limited. They only targeted US persons from participating in the primary market for new Russian sovereign bonds issued after either August of 2021 or January of 2022. But they, again, only primary market. So once a sovereign bond hit the secondary market, there were no restrictions from a US perspective or from any of the others. Now, all of US, EU, UK are prohibited from buying any new Russian sovereign bonds that are issued after March 1st. That's a very clear intent to prohibit US, EU, UK persons from funding the Russian government, which from a policy perspective, you can see the rationale, which is nice because sometimes you can't. There's a complication though with respect to those previously issued sovereign bonds, and that's because again, late February, the US implemented new novel sanctions that specifically targeted all US persons. So with Sberbank, it's just US financial institutions. For the Central Bank of Russia and the Ministry of Finance and this other entity, the National Wealth Fund, all Russian government agencies, all US persons are prohibited from engaging in transactions with those entities, again, unless there's a general license that applies. And the idea for this, the idea behind these sanctions is to cut off the revenue generating ability of the Russian government, where certain payments were being made through the central bank or through the Ministry of Finance. And the complication for Russian sovereign bonds is that oftentimes, the nominal issuer or the servicer of these bonds is either the Central Bank of Russia or the Ministry of Finance. So the reason it was kind of done in this weird step fashion is initially it was only new Russian sovereign bonds that were restricted, and old Russian sovereign bonds were completely permitted, all transactions. And at that time, February 24th, there were no restrictions on the central bank or Ministry of Finance. So there was no need to sort of clarify or think that those old bonds were affected. At the very end of February, the US came out with these special restrictions against the Central Bank of Russia and the Ministry of Finance. The EU and UK have similar but slightly more nuanced and targeted sanctions. But once the US said US persons can't deal with the central bank unless a general license applies, then to the extent the central bank was going to be involved in making a coupon payment on an old Russian sovereign bond, this new restriction meant that that interaction would now become prohibited unless there's a general license. So this is when General License 9A came out, which is a modification of General License 9, which is the securities of SDN banks. And the reason they put 9A is that there was a new provision added that said, U.S. persons can deal with the Central Bank of Russia and the Ministry of Finance with respect to accepting coupon and principal payments on these old Russian sovereign bonds up until May 25th of this year. So that's a very long-winded way of saying that U.S. persons remain completely permitted to trade in Russian sovereign bonds issued prior to March 1st, however they want. You can buy them, you can sell them, you can hold them, you can accept coupon payments and principal payments until May 25th. But after then, your ability to accept coupon payments and principal payments in any way that would involve the Central Bank of Russia or the Ministry of Finance is going to be prohibited. So this obviously affects the valuation of those securities after May 25th. If you think that you're not going to be able to get the coupon and interest payments to which you are otherwise entitled as a result of being a legitimate bondholder, you could still sell them past that time. You could even increase your holdings if you want of old Russian sovereign bonds. But it's just that specific receipt of payments that's going to be an issue. There's still some time for this before these restrictions take effect. So we'll have to see exactly what happens. I've heard that there might be some attempt to change payment flows to the extent that Ministry of Finance or Central Bank might have otherwise been involved. If it's a non-sanctioned bank or agency that makes these payments, then that might be a way for bondholders to continue to receive interest and coupon payments without running afoul of these restrictions. But right now, it's certainly something to monitor during the next 7 weeks or whatever we have. Because post May 25th, there's a real risk that even though you're allowed to hold the bond itself, you won't be allowed to accept payments related to those bonds. The only other thing I wanted to flag here is there's also a General License 13 that authorizes U.S. persons to engage in all transactions with the Central Bank and the Ministry of Finance that relates to things like payment of taxes, obtaining permits, obtaining licenses or registrations that require payments to those entities. There's a general license that authorizes those types of transactions until June 24th. And that's just a simple sort of like continuity of business. Like without this type of authorization, any company that needs to make payroll taxes in Russia wouldn't have been able to do so because those payroll taxes involve payments to the central bank. Same with respect to companies that export items to Russia and have to pay value-added taxes, or companies that need to obtain business operating licenses or renew their operating permits. All of those activities would have otherwise been prohibited if not for this new general license. So again, it's set to expire in June 24th, which isn't that long if you're a company that has actual operations on the ground in Russia, or you're the type of company that has to make payments, these tax or other payments to Russia. So it's going to be something to monitor. I think most likely outcome is that this general license will just be extended as we get closer to June 24th. Because the U.S. still doesn't want to fully shut out U.S. businesses from Russia. If they wanted to do so, they could, but they have not done that yet. So to the extent companies continue operating in Russia, they need to be able to make tax payments to Russia. Otherwise, they're just risking nationalization of their assets or nasty litigation involving the government. So it's something to monitor, but the two main general licenses you have to keep in mind when you're dealing with Russian sovereign bonds, General License 9A, and then General License 13 to the extent you have other interactions with the central bank that might be required. There's one other that I didn't put on here just because I tried to keep the text to a minimum, and I put a lot on here just for takeaway purposes, but there's another General License 9, another General License 11 that says U.S. persons are permitted to interact with the central bank to the extent the central bank is just operating as a clearing center for another transaction. So that's helpful to the extent they're acting on behalf of a non-sanctioned issuer, and there's some payments that need to be made to or through the central bank. There's a pretty bad carve out for now with respect to that role of the central bank and Ministry of Finance as well. The other set of sanctions that are a little bit easier to understand, but are still kind of leading to some confusion in the market, are new debt and equity restrictions. So again, I'm going to try not to talk too much about old stuff, but in 2014, that's when the first major Russia sanctions were imposed. And at the time, OFAC, the Office of Foreign Assets Control, They implemented what's known as the Sectoral Sanctions Identification List, the SSI list. And under that, there were various so-called directives. And all of these were completely targeted toward Russian energy, finance, and defense companies. And they were intended to effectively prohibit US persons, and the EU and UK did similar measures, from providing new financing to those targeted Russian companies. So the way it was worded is that to the extent, at the time it was VTB was just subject to these more narrow restrictions. So if VTB were to issue any new securities, whether they're new bonds or new equity, then US persons were prohibited from any primary or secondary market dealing in those securities, with the thought that by choking off new rounds of financing, the company would be hurt. But those did not affect secondary market trading in existing securities because the benefit had already been obtained through the primary issuances by those issuers, which makes sense. So those SSI list restrictions still remain in effect. It's just they've been superseded in many ways by the movement by some of those targeted banks to the SDN list instead of the more limited SSI list. And for some reason, OFAC felt the need to create another set of directives, one of which is identical to Directive 1 under the SSI list, but it's actually called Directive 3 under Executive Order 14042. Not to get too confusing, but people talk about old Directive 1, new Directive 3, but they both prohibit the same type of thing, which is they prohibit US persons from dealing in any new debt with the maturity of more than 14 days issued by the targeted companies. So that basically means for you guys, bonds, any publicly traded bonds which have a maturity date of more than 14 days, which is every publicly traded bond, and then any new shares, whether they're ADRs or domestic securities issued by those companies, is also off limits now as well. Again, no effect on previously issued securities, but as of February 24th, which is when all these sanctions were added, Gazprom or Alfa Bank or Russian Railways or any subsidiaries of those companies issues new equity or debt, US persons and EU UK persons as well, depending on what specific list you're looking at, are now restricted from purchasing those securities, again, secondary or primary market. Again, important, old Gazprom bonds are not affected by these new debt and equity restrictions. Gazprom previously was not subject to any of the new debt or equity restrictions. It was just subject to some limited oil and gas related activities. And now it's been moved to this new debt and equity restrictions list. But again, in any jurisdiction other than Canada, there's no asset freeze for Gazprom. I just want to know that, so no restrictions on previously issued securities, unless those securities were somehow captured by those SSI list security restrictions that were in effect. Because there's some duplication. For example, Sparebank was already subject to those SSI list restrictions. It was again added to this new list. Same with Gazprom Bank. It doesn't really have an effect because you were already prohibited from buying any new equity or debt that was issued since 2014. And you remain prohibited from dealing in any new debt or equity issued now. But just worth flagging that there are some duplication, but also some new companies. Oligarchs. So the EU and UK have been tremendously active when it comes to imposing asset freezes on Russian oligarchs. And I've named some examples here that are sanctioned by both both the EU and the UK. This is important because in the EU and UK, sanctions restrictions apply to any entity that is owned or controlled by sanctioned parties. But as I've noted, the EU UK sanctions generally do not affect secondary market trading of sanctioned companies to the extent those shares were already previously issued. The US would impose restrictions on secondary market trading of companies that are 50% or more owned individually or in the aggregate by sanctioned parties. But for now, the US has not yet imposed many sanctions against oligarchs. There have been a few, and there have been some that have been targeted since 2018. A handful more were targeted last month, but they've not come anywhere close. The US has not come anywhere close to the level of the EU and UK. Why this matters is if the US starts imposing those SDN sanctions against the same universe of oligarchs that the EU and UK have, including Mr. Abramovich, Friedman, and Mordashov, then any companies in which those individuals own an aggregate ownership interest of 50% or more, then there will be secondary market effect on previously issued securities. We'll just have to see which companies are owned, which companies are targeted as a result of the oligarchs, what creative changes there have been made to shareholding structures by those companies to sort of reduce the oligarch ownership below 50%. Because that's what a lot of these companies are trying to do now that they've seen writing on the wall. There's a lot of fast rejiggering going on of who owns what and where it's held, whether it's captured by sanctions. Most of which is completely legitimate, but it'll be important to see how much of it is fully legitimate if and when the sanctions come out. But this is more of just like a warning flag that if and when OFAC starts issuing SDN sanctions against oligarchs, there will be effects on securities that are in the publicly traded market that currently are not fully sanctioned from a securities perspective. That said, an ongoing theme throughout all this is it doesn't really matter what the law says. What matters is what the market will bear and what your intermediaries will do. And in many cases, if a company is considered to be controlled by an EU sanctioned party, there's some brokers and custodians out there that are refusing to handle any activity related to that company, even though there are strong arguments that secondary market trading of their securities shouldn't be captured. But even those legal arguments are going to disappear if and when OFAC starts sanctioning the same group of oligarchs. Again, we're cognizant of time, and I want to try to stop in 8 to 10 minutes just to leave the time for questions. I just have 3 more slides. Just want to quickly note other export sanctions restrictions because a lot of these are being talked about in the news. There's significant expansion of export control restrictions, both from the US, EU, and UK on so-called dual-use items and luxury goods to Russia. And so this includes not only things like luxury cars or fancy watches, but pretty much every telecom-related item is subject to some control as a dual-use item, and as well as any item that makes use of encryption. A lot of low-level electronics goods are controlled as a dual-use item, and historically none of these required licenses for Russia, but now they almost all do, and that's significantly impaired the ability of many Russian companies to obtain goods that they would normally use for their own development of products. It's also really affected the ability of subsidiaries of Western companies who operate in Russia to obtain raw materials and inputs from their affiliates or from other Western suppliers to continue their business. So that's not a directed prohibition on investment in those companies, but it has had an effect on their ability to do their jobs, which effectively impacts their commercial activities. So just wanted to flag that for you all in case you've had to deal with that. As a related point, there's this expansion of what's called the foreign direct product rule on exports to Russia. I'm not going to get into too much detail here, but what this means is that not only are you restricted from sending US telecom equipment to Russia right now, you also are restricted from selling non-US items that are made on the basis of certain US origin technology or software. So if you ship technology to a European factory or a Chinese factory, and that Chinese factory makes something using the US origin technology, now even that resulting product can be captured by these US export control laws and restricted for export to Russia, even though in the past there would be no ability to assert that jurisdiction. So this was used primarily for Huawei from a semiconductor perspective under China sanctions, but it's now been expanded to include all Russian exports, particularly Russian military exports. Again, not direct impact on your ability, but a lot of companies that depend on US origin software and technology to make their products have now been inadvertently caught up in these export restrictions, inadvertently by their point, but inadvertently by the US government because they meant to go after these types of activities. Finally, there's a US import ban on Russian oil and other energy products, including coal and certain other natural gas, as well as Russian origin seafood and alcohol products. Again, not a direct impact on what companies you can and can't invest in. This is not saying you're prohibited from investing in all Russian oil companies. You still have to look at the other restrictions, whether they're on the SDN list, whether they're subject to the new debt or equity restrictions. But it does mean that these industries are increasingly under focus, and it does suggest that to the extent sanctions expand, it could involve at some point an expansion of sanctions on companies in those industries beyond what we have. And that expansion could include restrictions on securities and secondary market trading. In the last few minutes that I had, I just wanted to flag some issues that I've been discussing with clients about investments and investors. So I've already discussed here, securities issued by a sanctioned entity and the difference in treatment from the US on one hand and the EU and UK on the other. The EU has issued some fairly nebulous guidance that people are still trying to parse through, but for them, it's not as clear how they view secondary market investments in publicly traded securities, but the common understanding over the years past has been that they are not affected. So we'll just have to see what more guidance comes out from the EU and or UK on that perspective. But be aware that there's a very clear difference in treatment, whereas the US clearly captures all securities, new and old. The EU, UK might just capture new securities and not necessarily old ones. Sovereign bonds I've already discussed at length, so we don't need to spend too much time. Investments in funds with exposure to secondary sanctioned securities. So what this means is if you have like a fund of funds, or you are a fund that otherwise invests in ETFs or index funds or mutual funds, and you may not have full visibility into what securities those funds are in turn investing in. Under the China sanctions, the China military CMIC sanctions, China military industrial complex sanctions, those were issued initially by President Trump in November 2020, and then were amended last June by President Biden. Those were in many ways the broadest investment-related sanctions that we've ever seen. And that remains the fact, because it included not only investments in securities issued by targeted companies, but also investments in any fund or any other security that was a derivative of or designed to provide investment exposure to a sanctioned Chinese company. So as a practical example, China Mobile was one of the companies that was targeted. And if you had an ETF that held a single share of China Mobile, then that meant that US persons could be restricted from investing in that ETF, even if that was only one share out of a million shares that the fund holds, because US sanctions would consider that fund to be providing investment exposure to China Mobile. And there's some nuances that give you some additional flexibility, but I'm not going to focus on those here. I can talk about them later. But for the Russia standpoint, we do not have this concept. So there is no investment exposure risk as a general matter. Those terms are not being used in the regulations or the order. The only restriction is if you have a fund and that fund holds 50% or more of its value in sanctioned securities. So if it holds 50% or more of VTB stocks or new Russian sovereign bonds, then and only then are US persons prohibited from investing in that fund. That's a super high threshold for any sort of emerging market fund or any sort of diversified fund index, where you're just not going to have that level of exposure to sanctioned securities based on what's considered sanctioned now. But because so many of us have been pretty scarred by the China sanctions, I just wanted to raise and dismiss this as to why it's not a concern. Derivatives are a little bit trickier. Under the US sanctions, any derivative product whose value is linked to a security that is sanctioned are considered to be sanctioned themselves. There's a little bit of flexibility when it comes to maybe synthetic instruments that aren't directly tied to an instrument. They don't directly give you the right to buy or sell the VTB security at some point in the future, but it's just the value might be linked, might be a CDS or some other instrument. There's a lot of nuance involved. You have to look at the specific facts, but derivatives can be problematic, but in some cases they may not be. So I don't know how much more lawyerly I can get, but pay attention to it, but you might not be stuck. I've already discussed the use of sanctioned parties. So SDNs, VTB shouldn't be your research provider or your custodian at this point. They should be completely off limits. And then reporting requirements. If you hold securities as of May 25th, you'll need to block them. If they're SDN securities, you'll need to block them and report them to OFAC within 10 days. Your custodians are also under a similar obligation if they're US persons. So we generally recommend coordinating, but just because your custodian does it, you're considered to have control over the securities, you might have an obligation as well. Sanjay, I have one more slide. Did you want to ask some questions, or should I try to power through these really quickly?
Let's just go. We did get several questions, so hopefully we can address them at the end.
Okay, great. So turning from investments you've made, so this should be sanctioned investors, so I'll correct that. Sanctioned investors. There's a large number now of oligarchs who are being sanctioned, and that can be an issue if these sanctioned persons have invested in your fund or if you otherwise manage their assets. Because if they're on the SDN list, then you are supposed to freeze any assets of sanctioned parties that are under your possession or control. So this is consistent across the US, UK, and EU. So if you have an EU sanctioned investor and there's some EU nexus because it's a UCITS or a Lux fund, that fund has to freeze that person's shares that are in the fund. And it's a little tricky because some people want to say, well, can't I just compulsory redeem them and hold their funds, hold the proceeds of that redemption in a separate account? Because I don't want them in my fund, I want them out. But you're not actually allowed to compulsory redeem them because that would be considered to be dealing in an economic resource of that sanctioned party. And so by redeeming them, you are now you've now engaged in a prohibited transaction involving their property. So what you have to do is you have to freeze their shares, but they're going to remain investors in your fund subject to the fluctuations. So their NAV is going to keep changing on a daily value, even though you want them out. And the way that could potentially pose a problem for your fund is if your fund somehow becomes 50% or more owned by sanctioned investors because they hold 50% or more of the shares of the fund, then all of a sudden your fund could be considered a sanctioned entity, even if it's only sanctioned due to the connection to the investors. So again, that's hard to have any of these individuals who directly or indirectly own 50% because typically, even if they're incredibly wealthy, their specific share of your fund is going to be nominal, but just something to keep in mind. Finally, just voting and decision-making rights. If you freeze the shares of a sanctioned party who's invested in your fund, they shouldn't be allowed to exercise any voting rights to the extent they have any. And if it's not clear, to the extent you own a security of a sanctioned company, once General License 9 expires, you won't be able to exercise your voting rights in that company either. Okay, with that, I guess, Sanjay, we'll have some time for questions.
Yeah. So we received several through the chat box, but we also did receive one prior to today's webinar. Do you want to maybe just address that real quick, and then we can move on to these?
Yeah,
that had to do with the custodian. That was yeah.
Sure. So this question is a great example of, I'd say, the very conservative approach being taken by certain market players. And in this scenario, there's a member who has a custodian, and the custodian has told the member that they are going to be ejecting a client's assets and will no longer be providing custodial services to that client because that client has a Russian home or legal address, so it's a Russian resident. That person is not sanctioned, they just live in Russia. And this custodian is saying, we're no longer going to provide custodial services on behalf of that client. And they've given a month to transfer out her assets. And this member is not happy about this because after that date, the custodian has said that the custodian is going to be restricting the account's liquidations only and are reserving the right to unilaterally liquidate the positions, even though we're not sure how they're going to do the cash or get the cash to that investor. So this is, to be clear, not a legal requirement. There's no restrictions on dealing with people in Russia or with in Russian investors unless they're sanctioned. So this custodian is grossly overstepping the bounds of what's required to be done under the law. But a lot of people are just trying to de-risk by completely getting out of Russia entirely, either because they think that they just don't want to be seen as facilitating business with Russia, or because they're afraid that at some point there could be stronger sanctions against Russia that would effectively prohibit all these activities of the type that they're doing now. It's kind of hard to deal with conservative intermediaries and service providers like this. They often are very well aware of what the law is, and they know that they're overstepping. They'll just say it's a policy decision. I still recommend trying to fight back because sometimes it's just people who have misunderstood the law. If you read a Wall Street Journal article about what the sanctions are, that can be very different from actually reading the OFAC regulations and the orders and the guidance, because there could be some gross oversimplification of what the sanctions are actually doing. But try to convince them, and sometimes it's just a matter of getting your compliance people or your outside counsel to talk directly with their compliance people as opposed to business people talking to one another. But you shouldn't be expecting success just because you have a strong legal argument, because in many cases they know what they're doing is not legally required. They're just taking a policy standpoint.
Yeah. Well, thanks. Okay, so the first question that we got through the chat box: if a fund holds a sanctioned security and it's not able to sell the security because the value is worthless or no one's willing to buy it, and doesn't the May 25th deadline under the 9A licensing put you between a rock and a hard place in terms of getting rid of the security, particularly given the Russian market sanction restrictions and allowing foreign investor trade? So
Yeah,
what are some options there?
yeah, it's a good question, and it does put you in a hard place because OFAC is now saying that if you haven't been able to sell by May 25th, then you have to block it. What I think it's not maybe the hard place isn't quite as hard because OFAC hasn't said that if you continue to hold the security after that point that it's prohibited, it just becomes a blocked asset. So you are functionally unable to sell it, but you haven't broken the law if you haven't been able to sell it by May 25th. And OFAC acknowledges that. You just have to freeze it and submit a report to OFAC. But that report is not an admission of a violation. It's just an admission that you're holding blocked property. The violation would occur if you sold it without the proper authority. But again, continuing to hold is not a problem. So the hard place is that now you have an illiquid security that you won't be able to sell unless OFAC issues a specific license, meaning like they tell you, investment advisor ABC, that you can sell it, or they extend the general license. But there's no real other option other than trying to maybe get it to the hands of maybe a non-US fund prior to May 25th. Maybe you have a vehicle that is a non-US person that is able to take these securities on, and you just want your US fund to be clean of it. But what a lot of clients are sort of now asking themselves, rather than deal with this May 25th deadline and the blocking requirements, should I be doing everything possible to sell at any cost, no matter how big my loss is, because I'm staring at this May 25th deadline? And that's a business call. Like, no one is telling you that you have to sell. And in many cases, clients are saying, these securities are effectively useless or worthless, but we think that in the future they could have value. And if you're in that boat, then you shouldn't rush to sale at the current price, because if you expect a rebound, even if that rebound happens after May 25th, you can hold the security after May 25th, and maybe the rebound occurs and you're still not able to sell the security, but at least you wouldn't have locked in the losses that you would have otherwise if you tried to sell at whatever cost.
Okay, so the next question is, certain banks are exiting certain Russian ADR and GDR programs. Are there any sanction restrictions on converting ADRs and GDRs to shares, to local shares, to reserve ownership?
Yeah, another good question. Not right now, no sanctions restrictions currently. The concern would potentially be if the Russian ADR or GDR is related to an SDN company, then there might be unwillingness of banks and other companies to process that conversion. But that said, if the SDN is covered by General License 9A, like one of the banks, then that authorization until May 25th would authorize all conversions. And if it's not a sanctioned security, and there's not otherwise like a sanctioned bank, like it's not VTB that's doing the converting on behalf of a non-sanctioned party, then there's no general restriction on dealing in conversions into local shares. From the U.S. perspective, again, like from the Russian perspective, as the previous question alluded to, there's Russian market restrictions on allowing foreign investor trading, but a lot of these ADR GDR conversion approaches are being done actually pursuant to Russian law under consideration that might require Russian companies that have ADRs and GDRs to forcibly convert those DRs into local shares. So there's actually a second reading of that bill happening tomorrow in Russia, where it might not just be a decision by a US or UK or EU bank. The Russian issuer might be required to do so under Russian law, but currently no sanctions restrictions.
Okay, so if we have another subsidiary that has a relationship with a Russian brokerage firm, not an SDN, in which we provide research and recommendations of US equities, does this pose a problem? Do we not have to manage any of the assets? We do not have to manage any of the assets related to the research and don't know who their clients are.
Yeah, not a problem here. I'd say the only problem would be if your research and recommendations start recommending purchases of securities that US persons can't buy. Then that could be a problem if someone down the road acts on your advice. Like you could have facilitated an activity by a non-US person that you shouldn't have done directly. But in general, if you're sort of staying within the bounds of what US persons can and can't do, and your Russian brokerage firm isn't an SDN, that type of relationship doesn't raise an issue.
Okay. I think this is another related question to the ADRs and GDRs. So the question is, technically speaking, trading in these instruments probably are not banned, correct? Right.
So it's a difference in opinion between the US on one hand and the EU, UK on the other. So ADRs and GDRs of SDNs, again, the specially designated nationals, are restricted under US sanctions. So US persons cannot trade in ADRs and GDRs of sanctioned parties unless a general license applies. That is not the case with respect to EU and UK sanctions, again, barring further clarification, where those EU-UK sanctions would not restrict trading in previously issued ADRs or GDRs because of the terminology that they use. But the US sanctions would prohibit those.
So there was apparently an FAQ 1002 where OFAC says US persons should also exercise caution in engaging in foreign exchange transactions on the Moscow exchange, given the current heightened risk that the Central Bank of Russia Federation could be a counterparty to such transactions. So the question is, how does this impact investment advisors, custodians ability to exchange RUB dividends that are received into US dollars?
Yeah, it's a good question, and frankly, we don't know the answer yet. OFAC, the most annoying thing that OFAC does is they'll offer these sort of vague statements that then don't have practical guidance as to what you're supposed to do to address. Again, we can exercise caution, but what do you want us to do once we've exercised it? But I think as a practical matter, if the central bank is involved, then your custodian is going to be very reluctant to engage with the central bank in any sort of like this type of exchange transaction. Again, there's this general license that says to the extent the central bank is just involved in like the clearing capacity, then that's permitted. But just because a general license exists doesn't mean that custodians and banks have to honor that general license. So I anticipate that this question is a very intelligent question that is looking into the future and is going to see practical and logistical concerns arise where you might not have a strict legal barrier.
Yes, our members ask great questions. So you talked about the reporting requirements. When do they take effect? And also, can you point to where in the rules we can find more information about reporting requirements?
So the reporting requirements for SDN securities, again, so VTB and VEB, that you either weren't able to or didn't want to sell by May 25th. The important deadline to keep in mind is the expiration of the general license. So right now it's May 25th. Once May 25th comes and goes, 10 business days after May 25th is when the initial report of block property must be filed with OFAC. So it's 10 business days after the blocking requirement takes effect. The blocking requirement doesn't take effect until May 25th. However, after you've submitted the initial report, there's an annual report that has to be submitted by September 30th of each year with respect to any block property that you held as of June 30th of that calendar year. So what that means is a practical standpoint, if you hold VTB bonds, you couldn't sell them. May 25th comes, then 10 days after that, 10 business days after that, you have to file the initial report. If you still haven't been able to sell them by June 30th because the general license wasn't extended or because sanctions remained in place, then you'd have to file an annual report every year thereafter. The reporting requirements aren't spelled out in the Russia sanctions. You have to go to like the general reporting and blocking FAQs of OFAC to see how they all interplay.
I think you had mentioned going back to the OFAC May 25th deadline, you're expecting that may be extended?
I think it's likely, especially if there's just illiquidity in the market as a practical matter. But I can't guarantee that it'll be extended.
All right. No. Okay. So let's end on a hopefully an optimistic note. You talked about looking down the road. So the last question is, even with a ceasefire or a ceasefire, do you think the sanctions and regulations will stay in place for a long time?
I unfortunately do expect some form of sanctions to stay in place for some time. I think even if it's just a ceasefire armistice, someone would have to really, really trust Putin to honor every commitment that he makes, to say, well, in that case, we trust you, all the sanctions are lifted. There's certainly going to be like a graduated, a gradual loosening of sanctions, and then it might just be a point of negotiation, like which ones are removed first. One would hope that in many ways the sanctions that have affected the West the most, like the VTBs in particular, like the sanctions on VTB and VEB, which were there like in Sparebank, which are large, Western counterparties of a lot of Western clients, those might be restricted. Those might be lifted first to sort of like a show of good faith. But I think Putin and Russia are going to have to make significant commitments, not only to withdraw the troops and then to withdraw them all, but also from a reparation standpoint, because there's been significant damage and a lot of these civilian casualties. So it's not just, okay, once the last tank crosses the border, we're going to start removing sanctions immediately. It's going to take time after that. And even then, I think there's going to be a lot of strings tied to how much Russia needs to pay to make things whole again. But I mean, I'd rather be talking about that world, about, okay, when can we start loosening sanctions as opposed to, the continued atrocities that we see nowadays.
Yeah, unfortunately, we're still in this world. And I know you're very busy these days, given everything that's going on. So on behalf of our members, we really do appreciate you taking the time to spend and give us your views and be here with us today. So and to answer questions. So thank you very much. And please do reach out to Darshak if you have questions or follow-up issues that you'd like to discuss with him. He's told me that he'd be happy to discuss those with you. And so his contact information is on the slides. So thank you everyone for listening in today. And thank you again, Darshak. Maybe hopefully this will end soon, but in the meantime, I know you're really busy, so I'll let you go. All right.
No problem. Thanks
a lot. Yep. Take care.